Good morning, everyone, and welcome to today's webinar about off-payroll working in the private sector, or what many are now calling the IR35 reform. My name is Stephanie Wilson, and I'm the tax partner responsible for leading BDO's national employment tax offering. I'm joined today by Jackie Roberts and Rob Woodward, who are both Associate Directors specialising in employment tax. Both Jackie and Rob are primary authorities on the tax implications of off-payroll labour. Our objective for this morning is not only to explain the new rules, but also to provide some colour on the subject and suggest what action you could valuably take within your business to prepare for the future changes, as well as to understand your current compliance and risk profile. We will make sure that we stay within the allotted hour, including a Q&A session at the end of the webinar. Please do submit your questions at any time during the presentation, and you can do that by inputting them on the right-hand side of your screen where it says to all panellists. The new legislation to be implemented from April 2020 will apply across all industry sectors, and whilst there has been a new regime in the public sector since April 2017, from next April, both private and public sector organisations will be subject to the same requirements. So to recap on the history of IR35, the original intermediaries, or IR35 legislation, was introduced back in 2000 to tackle the government's perceived non-compliance with the PAYE and NIC obligations for what they viewed as pseudo-employees operating through an intermediary. In most cases, the intermediary would be a personal service company, or PSC for short. Under this initial regime, the PSC was required to assess whether their engagement was really one of employment, but for the existence of the PSC. Where the PSC considered that this was the case, there was a deemed employment, and the PSC would need to operate PAYE and NIC on payments received from the engager. Of course, many companies who engaged the services of workers operating via PSCs began to rely on the perceived protection that these engagements provided to them. That is, if the contractual and payment arrangements around the engagement of a PSC were robust, and if HMRC were to challenge the employment status of the worker, it was the PSC who would be held liable for any unpaid PAYE and NIC, and not the engaging company. However, HMRC have stated that although the old IR35 rules have been in place for almost 20 years, only 10% of those PSCs who, in their view, should operate PAYE and NIC withholding actually do so. With a lack of HMRC resources to enforce the rules, the government has now sought to shift the obligations of the PSC to assess the deemed employment status to the end engager. The first stage of the shift in obligations took place in 2017 for engagements where the end engager was a public body. And now, with effect from April 2020, this has been extended to the private sector, with both the private and public sector being required to adhere to the new rules. Before I hand over to Jackie and Rob, I would just like to flag that we will be circulating the slides and the recording of today's webinar to all those who have registered in the next day or so. As I've already said, you're welcome to submit questions to our speakers using the comments box, and we will run some Q&A at the end of today's event. If we don't manage to get to your particular question within the allotted time, please don't worry, because we will do our best to follow up with you afterwards. I'll now hand over to Jackie and Rob, who will go through the new rules, what action we recommend, how we can help, and some of our experiences to date, all designed to help you to navigate through the new IR35 changes. So, over to you, Rob.
Thank you. In conjunction with a shift in responsibilities, there have been a number of cases recently, some of which have involved high-profile people. And while these cases do provide a smattering of stardust to the sometimes staid world of employment tax, and they've meant that IR35 has moved from the business pages to the front pages, of more relevance to us that these cases provide some context on IR35. The rules that determine whether a person will be deemed to be an employee are both based on case law, but also remain unchanged as a result of the IR35 legislative changes. To recap, the key tests to determine whether someone will be deemed to be an employee are control, can the end engager control when, where, and how the work is undertaken? Personal service. Is the worker personally required to provide the services, or can they subcontract at their own cost to a substitute? Mutuality of obligation. Does the worker expect work to be offered, and when offered, does the end engager expect the worker to accept that work? While the determination is not based on simply ticking off factors for and against employment, it is important to remember that the absence of any of the aforementioned factors will not result in employment being deemed. As the determination is a question of considering the factors in the round, other considerations, such as the level of financial risk, help to paint a picture as to whether employment would be deemed. If, however, the role is a role that exists independently of the person holding that position, such as a company director, employment for tax purposes will be deemed regardless. Applying these tests to cases recently held, it is important to recognise that each case was heard on its merits and turned on different facts. So drawing conclusions from a wide range of tax cases involving TV personalities, radio presenters, chartered surveyors, computer-aided design technicians and oncologists will never be easy. But in summary, HMRC lost more cases than they won. And why was that? If we can draw any conclusions, one factor was that came to the fore was control. And the cases that HMRC won were where they could demonstrate a significant level of control over the work undertaken, and conversely, where the cases they lost, they were unable to do so. More emphasis was given in the cases for the ability of the end engager to control or otherwise the work undertaken, rather than whether the work could be subcontracted or not, and so demonstrates a shift more towards control than personal service. It is also important to note the significance placed by the tribunals on mutuality of obligation. HMRC's stated position is that mutuality is assumed to exist where a contract is in place, and this is a view that does not necessarily align with the rulings given. The difference in opinion goes to the heart of the reliability of HMRC guidance and the check employment status for tax tool, which many employers will turn to first to assist in making an employment status determination. And HMRC has promised to improve their guidance and CEST in light of both these cases and negative feedback received. And these updates are expected later this year, but that does not mean that employers should be doing nothing now. As Jackie will explain, the current responsibilities under IR35.
Thank you, Rob. I'm now going to recap on the current IR35 rules from the engager's point of view. So, from the engager's point of view, the pay-as-you-earn and national insurance obligations remain with the PSE as long as the contractual arrangements are robust. So what is robust? So, for a contract to be robust, the following needs to be evidenced. 1. There must be a contract between the engager and the PSE. Please note it's important that the contract is not a tri-party contract involving the worker. If this is the case, then IR35 is not in point, and the engager must consider their pay-as-you-earn and national insurance obligations. We've recently noticed more of a trend in the arrangements of using tri-party contracts, and unfortunately the type of contract renders the arrangements invalid, so worth noting. In which case, instead of the PSE being responsible for pay-as-you-earn and national insurance, the engager would be. Second point is the PSE must be incorporated in the UK. We would always recommend that companies' house is checked to confirm this. Where an overseas company is engaged instead, there is a high risk that HMRC would seek any pay-as-you-earn and national insurance from the easy target, the engager. So, thirdly, the personal service company should issue an invoice for fees, including any disbursement costs. And finally, all payments made by the engager should be paid direct to the UK bank account of the PSE. We often see cases where the engager reimburses expenses directly to the worker, and this can render the contract invalid. Where all of the criteria above are in place, HMRC are likely to pursue pay-as-you-earn and national insurance from the PSE and not the engager. Remember that IR35 also includes executive and non-executive directors that provide services via a PSC. A director is an office holder, and remuneration paid to an office holder for office holder duties is subject to PAYE and national insurance. In the past, HMRC challenged arrangements and sought pay-as-you-earn and national insurance from engagers where robust contractual arrangements were in place because the director was registered personally at Companies House. HMRC's view was that the personal appointment at Companies House invalidated the company-to-company contractual arrangements, and they would seek pay-as-you-earn and national insurance on this basis. However, the approach by HMRC has always been inconsistent in this area, and some inspectors would have accepted IR35 applied regardless of the personal appointment. HMRC's own guidance now indicates that they expect pay-as-you-earn and national insurance to be sought via IR35 by the PSC. That said, HMRC have stated where arrangements are set up for the avoidance of pay-as-you-earn and national insurance, they still reserve the right to challenge that pay-as-you-earn and national insurance should be sought from the engager. Although not seen all of the time, where a worker has a controlling interest in an engager company and operates via a UK personal service company, please note IR35 is not relevant, and which leaves the engager to operate pay-as-you-earn and national insurance. From an engager's point of view, employer compliance is not only essential for mitigating pay-as-you-earn and national insurance risks for a business, it is also essential for corporate criminal offence and senior accounting office purposes. Corporate criminal offence requires companies to have reasonable procedures in place to demonstrate a defence against the legislation. This means if an associated person of a company criminally facilitates tax evasion and the company is unable to demonstrate that it's taken reasonable procedures in place to prevent this facilitation, the business is guilty of a criminal offence. And an associated person for these purposes is very widely drawn and could include clients, customers, employees, agents, and contractors. It is therefore essential for you to understand your chains of supply, which involve entities such as PSEs, agency umbrellas, and make sure you implement procedures to mitigate these risks. I'll now pass over to Rob.
As we mentioned previously, position for workers providing services to public sector organisations through limited companies changed with effect from 6th of April 2017. While I will not be going into the finer details of these rules, it is important to remember that they only relate to the public sector, which in this context is organisations subject to Freedom of Information Act and therefore includes central, local and extended branches of the government such as the NHS and BBC. It is also important to understand the key principles underpinning these changes, as this is what in essence is being rolled out in April 2020 beyond the public sector to the private and not-for-profit sectors too. Since April 2017, where an individual has personally performed or is under an obligation to personally perform services for a public body and the services are provided not under a contract directly between the client and the worker but under arrangements involving a third party, more often than not a PSC, and the circumstances are such that if the services were provided under a contract directly between the client and the worker so that the worker would be treated as an employee of the public sector organisation, PAYE and national insurance must be operated on the payments for the worker's services. The obligation to operate PAYE and national insurance, where due, falls on the fee payer. And the fee payer is the public body if they engage with the immediate third party, in other words, paying the PSC directly. If, however, there is an intermediary paying the third party, such as agency, as part of a labour supply chain between the public body and the third party, then the fee payer will be the intermediary paying the PSC, as demonstrated on the slide. This may not necessarily be the agency with which the public sector body directly engage with. As the public sector changes are being used as a basis of the further extension of the off-payroll working legislation to the private and third sectors, they give us useful experience and pointers for the future. Firstly, and in contradiction to the legislation, a number of workers were deemed to be employees on a blanket basis. Individual assessments are a necessity, and it is impossible that time pressures led to some of these blanket assessments. Therefore, preparedness is key. Empirically, we understand that some of the decisions taken to determine whether a worker was inside IR35 was as a result of political pressure from elsewhere in the public sector and or the civil services political masters. And it is expected that the private sector in particular will not be as susceptible to these pressures and will take a much more pragmatic approach to making determinations. Thirdly, there was a significant confusion around outsource agreements and composite supply arrangements, whereby a business providing workers to the public sector did so as part of a wider agreement covering other matters such as equipment. Unhelpfully, HMRC guidance on such arrangements, whether they were caught, and if so, where in the supply chain the obligation fell, was removed years ago and has not yet been republished. While high-level examples have been given as part of the guidance for the public sector from HMRC, from further conversations we've had with the Revenue, it has been indicated more comprehensive guidance will reappear, having been updated to reflect the legislative changes. The other factors we noticed from the public sector changes, there are also cost pressures on end engagers, particularly the addition of employers' national insurance contributions and, where appropriate, the apprenticeship levy, increase the costs of engaging with a worker, as well as often squeezing agency margins. And where these costs fell and the ability to pass them on or not was a matter of commercial negotiation and reviewing contractual arrangements, thus further demonstrating that these changes go beyond tax and encompass legal, resourcing and procurement issues too.
Thank you, Rob. So, the draft legislation. So this was published on the 11th of July 2019. It's important to note that this is draft legislation and therefore our webinar is based on this alone. The legislation still has to go through scrutiny of the parliamentary houses before royal assent. However, if the draft legislation stays as it is, we would be expecting the private sector rules broadly mirror the existing public body rules explained by Rob. However, there are some significant differences that will apply to both the private and public sector from April 2020, and all of which place extra responsibilities on the engager. HMRC have also promised some additional guidance which we expect before the autumn of this year. The first change is that the engager is to communicate the conclusion of the status determination to the worker's PSE, in addition to the next one down in the chain. This makes sense, as previously the public body rules, the personals under the public body rules, the personal service company had no knowledge of the tax status determination until they received their fees net of pay-as-you-earn and national insurance. So this was allowing no time to discuss any potential disagreements with the conclusion reached by the engager. Again, reasonable care must be demonstrated. HMRC will not accept a blanket approach to all individuals providing similar services. And although reasonable care is not defined in the legislation, the subject has been heavily tested in courts, which is worth bearing in mind. The second change is that in addition to communicating the status determination to the PSE, the engager must explain the reason for its conclusion. Currently, we do not know what the rules are expecting this to look like, but the legislation refers to a document as a status determination statement, SDS. I think that's the word that we'll be seeing more of. Also, what is of particular note is that the SDS must be issued where it is concluded that the conclusion is one of self-employment or deemed employment, and the reasons why. it would be reasonable to assume that this is so HMRC has a clear audit trail of the communications made if there are any subsequent challenges at a later date. The third change is that the end engager must also implement a process to manage and deal with any disagreements received. These would be expected from the worker's PSE or fee payer, but it could be anyone in the supply chain. There will be a time frame for dealing with this process. The end engager must, within 45 days from receipt of the disagreement, either inform the worker or the fee payer that has considered the reputations made and has decided that the conclusion is still correct, i.e. the original statement of deemed employment still stands, and the reasons why this is the case. Or secondly, give the worker and the fee payer a new status determination statement, which contains a different conclusion and states that the previous status determination statement is withdrawn and why, i.e. the worker is no longer a deemed employee. Where the end engager fails to meet the 45-day deadline, the engager becomes the fee payer. The final change is to exempt end engagers classified as small. For a company and LLPs, this is based on the definitions in Companies Act 2006, as defined in the financial year ending in the previous tax year to the year in question that we are looking at. So, let's take a look at a diagram to help explain these rules. If we look at the top diagram, this shows a straightforward contractual chain between a client and a PSE. Therefore, in this case, the client is the end engager and also the fee payer. A status determination needs to be made by the end engager, and let's assume that the conclusion is one of employment. The client will add the individual to the payroll as a deemed employee for tax purposes only for any pay period after April 2020. The worker will be treated as having a second employment with the client, and pay-as-you-earn national insurance will be deducted from the net of VAT amount detailed on the invoice. Employers' national insurance and apprenticeship levy will also need to be accounted for. Any pension, auto-enrolment or employers' paid statutory benefits would remain the obligation of the PSE, as the PSE is the worker's primary employer. So we move to the bottom diagram. The bottom diagram demonstrates the rules in a more complex scenario. In this example, we have an end engager, an entity the end engager contracts with, as well as a PSE and a worker. Agencies listening will no doubt recognise that they are never the end engager, but more likely to be the entity closest to the end engager, or even further down the supply chain. In our scenario, the agency is closest to the PSE, and therefore the agency is the fee payer. The end engager will issue a status determination to the worker's PSE and the next one in the chain. Let's assume this time that the worker is genuinely self-employed. So the end engager informs the agency that the SDS is one of self-employment and the reasons why, and no further action is necessary. So what if the client is the entity between the PSE and the end engager and not a temporary supplier of workers, such as a consultancy company providing professional services? The question here is, who is the end engager and who is the worker providing their services to? Is it the professional services firm, or is it the end engager? We've come across many cases with our clients where this answer is not clear-cut. The end engager may be providing holistic consultancy services or outsourced services. When establishing who has the pay-as-you-earn national insurance obligations, it's necessary to identify the entity receiving the personal service of the worker. It may therefore be necessary to drill down into more detail to understand the engagements and how they work in practice and understand the workers' involvement in providing the services. We recommend those that listening to this recognise this scenario and are unsure should speak to employment tax advisors. When the public body rules were implemented, it was recognised that the NHS outsources many of its departments, and so helpfully, the majority of NHS public bodies that outsource services were exempt from the public body rules. And hopefully, HMRC will recognise that in the private sector there are a myriad of advisory outsourced services and provide the clarity in the anticipated guidance. I'll now hand over to Rob. No, I won't. I will continue. So, we thought it would be helpful to run through some considerations for a case study. So we have a theoretical client on this slide, large for CTA 2006 purposes, that engages various workers to provide services, which is the information that we know. The client is unclear of the potential new responsibilities and would like to understand any potential employment tax risks in preparation for April 2020. An initial internal brainstorming exercise of HR finance department heads has identified that the business pays the following: an outsourcing agency for cleaners and reception staff, self-employed IT contractors, an agency for IT contractors, a director via a personal service company for office holder duties only, and an umbrella company for more consultants. The client's first thoughts were that the employment tax risks were fairly minimal, with the exception, of course, of the arrangements of the director. They knew the director's services as an office holder were subject to PAYE national insurance and would be caught under the new rules. So we pointed out that the following should also be explored in more detail. So what we've done is we're looking at the current risks that need some more exploration. Are the IT contractors genuinely self-employed that we have here? Are there contracts in place? What is the nature of the engagements? It looks like there's an immediate and historic risk to pay-as-you-earn and national insurance. Also, are the contractual arrangements in place for the director's services robust? If not, pay-as-you-earn and national insurance might need to be operated by the client from the start of their arrangement. And what do the contractual arrangements between the client and the umbrella agency look like? How are the workers paid via umbrella agency payroll? Is it via a personal service company or on a self-employed basis? Are the services of the IT contractors and consultants onward supplied to clients or clients' customers? Could the client be caught for the new intermediary rules? If the services are onward supplied and pay-as-you-earn is not deducted by the agency or the umbrella, there may be a potential pay-as-you-earn national insurance risk and even quarterly reporting obligations. So quite a few things to think about there for the current rules. So then if we move to the future risks to consider the new rules from April 2020. What PSCs are in the supply chain? Firstly, it's important to know what a PSC is. So a PSC is a company or an LLP where the worker or connected parties own more than 5% of the PSC. But it can also be a partnership where the partner as a worker is entitled to 60% of the profits or more. Or most of the profits of the partnership are derived from the actual engagement. All of the above arrangements, with the exception of the self-employed IT consultants, could potentially be caught for the purposes of the new rules. We need to explore all of the contract supply chains to identify the PSCs and implement a process to prepare, send status determination statements to the workers and umbrella agencies. And then you've got the outsourced agency. What does that contract look like? What services are being provided? And are there PSCs in the chain? And are the workers providing personal service to the client? Maybe not. But we would recommend that the arrangements are considered in the first place, even if they are later dismissed as not relevant. So as you can see, there's a lot more to consider than originally thought. Just to finish on this, I'd like to say that from an IR35 readiness work that we have carried out to date with clients, almost all have led to identifying current non-payroll risks in their business as well as ones for the future. We are now working with them to implement new processes and policies to ensure any use of the non-payroll labour in their businesses are suitably mitigated and effective for SAO and CCO purposes. I'll now hand over to Rob.
Thank you, Jackie. As with all tax reforms, in order to encourage compliant behaviours and identify deliberate non-compliance, there are punishments for failure to operate. And as Jackie has already explained, it is the end engager's duty to inform the worker and the fee payer if they fall within IR35. Till such time as that determination is communicated, the PAYE and national insurance liability remains with the end engager. And this means that if the PAYE and national insurance is due and the end engager does not deduct the necessary tax and employee national insurance, plus pay employers' national insurance and the apprenticeship levy, and then report those to HMRC through the standard RTI mechanism as if the worker was a direct employee, the standard late PAYE payment surcharges and real-time information, incorrect and late filing penalties would apply as if a payroll was not being operated correctly for a direct employee. And these penalties include late filing penalties of £100 per month per 50 employees and late payment surcharges of up to 4% the total amounts due to be remitted to HMRC. Similarly, that liability to operate and report PAYE and national insurance can only be passed on if the decision is made in good faith and based on a reasonable assessment of the facts. And a lack of due care and attention in making the assessment will result in the liability remaining with the end engager. Of course, if the liability is passed on to the fee payer, they would assume the employer payment and reporting responsibilities, and if PAYE and national insurance is due but not paid or reported, the standard late payment and filing penalties, as already mentioned, would apply. One further factor is where liability has been transferred along the supply chain and there's a compliance failure, as we set up on the screen. Where a labour supply chain is involved, the public sector reforms in 2017 introduced the concept of a chain payment. Payment on which the PAYE and national insurance is due when the obligation is being passed along the supply chain from the end engager to the fee payer. The new legislation develops this concept and grants HMRC powers to transfer the liability up the chain where PAYE and national insurance is not operated on that chain payment. The finer points of these powers have not yet been confirmed, but in the responses to the consultation leading up to the legislative changes, it was indicated that the intention was the buck will stop at the fee payer rather than the end engager, except in extreme cases. And the exact details of the debt transfer powers are yet to be published and will be so as part of HMRC guidance. But again, as in the consultation responses, HMRC have indicated they will only transfer debt in circumstances of deliberate default or situations involving tax avoidance schemes. And regardless of how the debt transfer powers do manifest themselves, one key takeaway point is that end engagers must know who is in their labour supply chains, and only by performing supply chain due diligence will it be clear where the true risk lies. Jackie mentioned previously, this due diligence is also a requirement of wider tax obligations, such as those under the Senior Accounting Officer regime and the corporate criminal offence of failure to prevent the facilitation of tax evasion. While April 2020 may seem a while off, preparation should already be underway to assess the impact of the reforms. As discussed earlier, experience from the public sector changes demonstrate failures resulting from a lack of preparation. One of the key themes in the consultation feedback was that organisations need time to ensure their functions, policies and procedures for finance, tax, HR, legal, procurement, resourcing, onboarding, as well as payroll are ready. And in particular, organisations need to identify the engagement of workers through PSCs in their supply chains, as Jackie mentioned earlier. This should be part of a wider supply chain review because, as we have already said, obligations exist in the wider corporate tax regime that need to be fulfilled. Where off-payroll workers supplying services to the end engagers in a personal capacity are identified, there is a need to carry out the status determinations to identify anyone whose engagements will be caught or potentially caught by the new legislation. And there will need to be a commercial assessment on both the engagement of these workers going forward, but also the appropriateness of the engagement of workers through PSCs generally. As necessarily required, working relationships and contractual arrangements may also require amending. And this overall review should fit with a wider appraisal and update of current approaches, policies, processes and procedures. And in particular, organisations should be looking to dovetail their off-payroll working engagement policies with a wider company governance obligations.
Thanks very much, Rob. So we have had a few Q&As through, so let's just deal with those first up. Rob, no rest for the wicked. I'm going to start with you. So the question which has come through is, in BDO's experience, are businesses moving away from using PSCs and back to engaging workers on fixed-term or zero-hour employment contracts?
We have seen some, and seen some engagers taking that route, and some actually engaging with the individual, or indeed going through the agency route. In many cases, the decision-making process will ultimately depend on the importance of that worker and how they're engaged. So it should be a commercial decision as much as anything else, and should that worker rightfully be engaged as an employee or still through a PSC. From a commercial viewpoint, it does increase costs if you engage through as an employee, because they need to consider not only PAYE, national insurance, but like benefits and rights, whereas a PSC doesn't have employee rights or pensions, contributions, etc. So we have found where this has happened that PSCs may increase their rates. So again, there are cost considerations. And the final factor to consider really is around the employment law implications, and obviously we won't be able to go into those, but obviously need to consider that both from the company and the worker, both historically and also future, in consideration of the Taylor review that's also ongoing.
That's great, thank you. And you also inadvertently answered another question which somebody had put forward, which was, are there increased costs for the end user of new rules? And clearly there will be if PAYE and NIC needs to be withheld, because there's increased costs associated with that. So thank you very much. Jackie, let's come to you next. What is BDO finding is the biggest challenge for companies who engage PSCs?
A lot of that just really depends on the size of the business that we're working with. But if you take the larger businesses, the main issue has been for them to try and identify where the PSCs sit in their business. We've obviously already touched on, we're talking about personal service companies and LLPs and partnerships. But what we won't know off the top of our heads is the ownership of those personal service companies and LLPs. So there's some more digging to be done even once you've done that. Clients are tending to brainstorm where they think that personal service companies are in the business. But when it's a larger business, we found that it's actually a lot easier but more laborious to actually interrogate the purchase ledger to find all those personal service companies. There's also, I guess, when you're talking about the changes, and once you've identified them and you're starting to tell the PSCs if you want to advance, pre-warn them. There's an attitude change in the business. There are some, obviously, where those PSEs are invaluable to the business, and there are those that are just providing a service that could be dealt with by someone else. But some are actually not wanting to accept the process at all, and are leaving the business. So it just depends on whether that PSE and the supply of that particular work is paramount to the business. And I guess there's lots of education that needs to be done within the business. It's all very well the tax people understanding these rules, but it impacts on every part of the business, and it's trying to get the people in the business, in HR, in the engaging area of departments within a business to be on board with this.
That's great. Thank you very much. Rob, over to you again now. What are the key contractual terms that BDO would suggest bringing into our contracts with PSCs so that we can ensure that these workers are not going to be caught as deemed employees?
I suppose the first thing to consider is that the contract needs to reflect reality. So, and while the contract will be the first thing that people would review, actually you can put whatever you like in the contract, but if it doesn't reflect reality, then you can't just say, oh, it automatically makes someone self-employed or outside of IR35 just by putting terms in a contract. It needs to reflect what's there, and if it doesn't, then it will be ultimately ignored. The key considerations really, obviously there should be a contract. That's obviously good from a risk management point of view and establishing the nature of the relationship. But the importance is obviously establishing the need for the business to access the worker. So if you need to have that worker, and they need to, the business needs should be that they should be engaged in whatever is most appropriate to get their hands on the services and have been provided, rather than simply adding clauses or changing clauses within a contract to not reflect the situation and the reality. In terms of if there are things to be considered and where to focus on, obviously the bits we've mentioned previously around control, demonstrating that there's a limit on the control that can be exercised. Substitution clauses were obviously very popular in the past, and obviously breaking that link between the personal service and the work, more indication of self-employment. And similarly, the piece around mutuality of obligation, so contracts should be time limited. But as I said, there's no magic bullet in terms of what you can add to change the contract to change it to that someone's automatically going to be self-employed. You have to look at the wider picture.
That's great, thank you. I have had a question come through which I'm actually going to take offline, and I'll go back to the person who asked that question directly, because it's specifically about payroll, and that will depend on how your payroll is run for us to be able to help you with that question. Another question which has come through has been about who to contact at BDO. The slides and the information with the details of how to contact either myself, Jackie or Rob will be circulated, so they will come through to you. But one of us three, unless you have a local office contact, would absolutely be happy to help you. Right, so I am very conscious of time, and currently I've run out of questions, so I'm going to move on to the last slide, please. So this is the closing comments, and really just to say thank you so much for joining us today. As will have become clear during the last hour or so, this isn't a straightforward topic. It's a much bigger thing than clients, companies tend to imagine it will be. And in our experience, many employers are struggling with the basics of identifying exactly who their off-payroll workers are and whether they're engaged via an intermediary, can't say it, or agency, or a PSC, or whether actually they're just engaged as self-employed workers, and if they are, whether they are rightfully and properly engaged being self-employed. And I think for me, that is the main takeaway that from the draft legislation and the messages from Jackie and Rob is please don't delay taking any action. There's an awful lot to do between now and next April. You might need to issue new contracts to all of your off-payroll labour. and none of us quite know what's going to be under that stone until you've picked it up and had a good look. So please do take steps to understand your off-payroll labour population, identify where the risks might lie, ensure that any new procedures are put in place together with new contracts before April 2020 where needed, bearing in mind that might need some education for your wider business where you might meet some resistance, and also consider what remedial action might need to be taken, if any. So that just leaves me to thank Jackie and Rob again for sharing their knowledge with us this morning, so thank you. And to confirm again that copies of the slides and the recording will be sent to all of those who registered to join us today. In addition, if anyone wants more information, obviously please do contact one of the speakers, but there is a brochure and a one-pager placemat available on our website, which includes a little more detail should you need it. On a final note, if you haven't yet completed our survey on the IR35 reform, please click on the link to do so now. So goodbye and thank you very much for joining us today.